I was hoping we could start with the basics. What is the International Court of Justice and what powers does it actually have?
The International Court of Justice is the UN court. It's the primary judicial institution of the United Nations, and it sits in cases where there are disputes between two states, where they're not able to reach an agreement about the interpretation of a treaty or something someone has done or about where a border exists. They sometimes go to the International Court of Justice. It's made up of 15 judges who come from around the world, and it's a very highly respected and authoritative body.
Genocide in international law is a carefully framed term. What is genocide in the legal sense, and what is the case against Israel?
Okay. Well, yes, genocide, it's a word that gets used widely in a more colloquial sense, but there is a precise legal definition of it in the 1948 Convention on Genocide, and it requires that there be the intentional destruction of a national, ethnic, racial, or religious group, in other words, a people. And the courts have interpreted this definition rather narrowly, so that they require the destruction to be physical in nature. In other words, it's not just expulsion or assimilation, but it has to be destruction of with a physical dimension. So that's the basis of the claim that South Africa is making against Israel. And they're saying that Israel's military activity in Gaza is not actually directed primarily at trying to destroy Hamas, as Israel claims, but that it's actually directed at the civilian population with a view to driving them out of Gaza or letting them die from hunger, disease, and so on. So that's the basis of the case. The hearings that took place yesterday and the day before that have got so much attention are not always well understood. The court is not going to decide whether genocide took place based on those hearings. This is just a preliminary skirmish between the two sides, between South Africa and Israel, to determine whether the court should make a preliminary order against Israel to preserve the situation. It's like an injunction to kind of freeze the situation, limit further damage to the Palestinians, so that eventually the court can make a decision which might be 4 or 5 years down the line.
Before we get to what the court could do, let's take a step back, if you wouldn't mind. What is the basis of South Africa's claim? Because what we know is that we can't get independent journalists into Gaza to witness what has been happening. So what is the evidence upon which South Africa has built its allegation?
Well, obviously, South Africa has the same kind of sources that we have access to as well. So there are a range of UN reports that have come out of various institutions within the United Nations, news media reports. Like probably many people, they watch Al Jazeera news and they get films from Gaza. So it's the kind of information, obviously, that's in the public domain. They have not filed their full case. So this is something that doesn't happen at the start of the proceedings. They kind of launch the proceedings, and then it's about 6 to 8 months. The president of the court will set the exact time for it. They have to submit their whole case, and then we'll see in full what all the evidence is that they may have.
So these are the opening salvos on both sides. As I understand it, what the South Africans essentially have said is that the Israelis have intentionally caused serious bodily or mental harm. They've deliberately inflicted conditions on a group of people that are calculated to bring about physical destruction in whole or part. They've imposed measures intended to prevent births within the group and forcible transference of children. What has Israel's response been?
Basically, Israel, the way the hearing took place was that South Africa set out its case on Thursday. And all of the information that they gave, these categories you read, are drawn from the convention. They're mentioned in the Genocide Convention as acts of genocide. On Friday, Israel really concentrated, they devoted a lot of time to talking about the attack by Hamas in early October, and basically set out the claim that what they're doing in Gaza is a military operation, and that they are taking all appropriate care under international law to protect civilians from harm. That was the core of the argument. And they said that they were that there was no intent to destroy the Palestinian people. So this is one of the central issues in the genocide case, is proving that there's an intent to actually destroy the group, and that the killing is just not something that's incidental or related to some other purpose. And there they were confronted by the South Africans with some very, very aggressive and outrageous statements by Israeli prominent figures in Israel, some of them ministers and politicians. And Israel tried to take its distance from that, being dismissive, saying these were people who weren't in power or who weren't so influential. So they were on the defensive on that point, and their answer was simply, these are not statements that we can attribute to the government and don't indicate an intent to commit genocide.
Understood. So I'm crystal clear on this. What the South Africans claim is that there is clear intent by the Israelis. So does that mean that recklessness, behaving recklessly, the Israelis behaving recklessly, would not be enough to find them guilty of a genocidal act?
Yes, I think that's correct. Reckless conduct would not meet, it's a very, very high threshold for a conviction for finding a state to be responsible of genocide. It's like the beyond a reasonable doubt requirement, and it requires full criminal intent. But to win the case, this preliminary stage on the provisional measures, they don't have to reach that standard. All they have to do is establish that they have a plausible case. And in my opinion, they met that without any great difficulty. So they're probably, we'll wait for a decision. There'll be a decision from the court on the provisional measures, probably within 3 weeks. And my opinion is that they've probably met the test, and they'll get an order from the court. And then there will be subsequent stages in the case going on for several years.
What can the court do? I understand this is a preliminary hearing, but what can the court actually do at the end of this preliminary round? Can it get Israel to stop bombing Gaza, for example?
It could order that to happen. In the case of Ukraine 2 years ago, the court ordered Russia to stop the invasion. Of course, Russia didn't comply with it. So there's a big issue of whether a state will comply with it or not. Depending on how strong the order is against Israel, we can speculate that if it's very strong, they will not be inclined to comply with it. Whereas there are more modest measures they could order that Israel might be able to live with. One of the problems that Israel is going to confront is that many of the countries that are very friendly to it, Western European countries, the United Kingdom, Canada, Australia, are very loyal to the court. And they're not going to be comfortable with Israel being too dismissive of something the court will do. So depending on what the order is, although it's not as if it can be enforced by some armed force going and moving into Israel, they'll be ordered to do it. They might defy it, but the more defiant they are, the more trouble they're going to have with their friends.
Does this really have any effect, even if Israel is found, if South Africa's application is upheld and the court judges that Israel has committed genocide or is committing genocide, what actual impact does that have on anything, given what you've just said is that Israel could just ignore the finding?
It's a good question. It's a very legitimate question. Of course, there have been all kinds of measures taken at the international level, including Security Council resolutions to try and resolve the Middle East crisis, but they haven't worked. It's been festering for 75 years since the creation of the State of Israel. It's been a central issue in the United Nations, and there's no apparent resolution. Perhaps this will change the chemistry a little bit. I think that's about the most one can hope for. It's a piece of an ongoing crisis, and maybe it will contribute, and maybe it won't. That's the best that I can say. I'm an international lawyer. It's what I do for a living, so I'd like it to work. But and there are many examples where orders from the International Court of Justice have been effective in solving problems. But this problem is, it's like no other problem, and not an easy one to solve. It may just amount to moving a pawn up one or two squares on the chessboard in a game that's far from finished.
Professor, one of the things that was mentioned repeatedly in the opening statement by the lawyer representing the South African government was the case of brought by Zambia against Myanmar in relation to the Rohingyas. You, of course, were one of the lawyers who defended Myanmar. Can you tell us a little bit about that case and what the outcome was?
Yes, it was filed by the Gambia, not by Zambia.
My mistake.
But it has many similarities with this case between South Africa and Israel in that it's filed by a state that had it's not what we call an injured state. It's not a state that has any particular, has not experienced any particular violence or impact as a result of the act of genocide that they charge the other state with committing. So they're acting as kind of international altruists, taking up an issue and fighting in the interest of humanity, one could say, at the International Court of Justice. I'm not involved in the case anymore between Gambia and Myanmar. I was involved in the hearing that took place in December of 2019 that's very similar to the one that just took place. It was about the preliminary measures, and Myanmar fought hard, as I did. It was my job to defend them and to try and challenge in the same way that Israel did yesterday. But ultimately, because the threshold is quite low, obtaining a provisional measures order in the circumstances is not that difficult to get. And this is why I think from experience in that case, my assessment is that South Africa will be successful as well. It would be stunning if the International Court of Justice didn't follow an approach similar to the one that it took in the case between Gambia and Myanmar. That being said, Myanmar is a small, isolated country without a lot of friends. Israel is a powerful, powerful country with big, powerful friends around the world. So, international law is also, it's a politicized environment, and it's one where there are a lot of double standards. So we can't rule out the fact that the International Court of Justice might behave differently because of the parties and because of the sensitivity of the issue that's involved. None of that can be excluded. But it's a court that's made up of a cross-section of judges from around the world, and they reflect the diversity of views around the world as well, the political views. So there are judges from Western Europe and from the United States who will be inclined to be friendly towards Israel in its claims, and there are judges from the South, from Somalia, from India, from Uganda, from Jamaica, who will be perhaps more inclined to take a position that's that of many countries in the global South.
But surely
they're independent people.
Yes.
Sorry.
Well, that was going to be my question, because surely this should be about the interpretation of the law rather than where you come from influencing that.
Yes, you're quite right. And the judges are independent and impartial, and I wouldn't want to suggest anything contrary to that. But they do reflect the cultures they come from. And that's part of the idea of the International Court of Justice, actually. It's not premised on the idea that you can get 15 judges who have been kind of neutralized so much that they don't reflect the cultures or anything. They are meant to reflect, to some extent, the cultures and the views of the countries where they come from, while at the same time behaving as an independent, impartial, and objective matter. I know it's a complicated idea.